Well, with the Rittenhouse case headed to the jury soon, there is plenty to unpack looking ahead to the verdict. So much going on, and joining us to talk about this process and exactly what the jurors are discussing is Michael Hart, defense attorney at Hart Powell SC. Thank you so much for being with us on this Monday afternoon. Things are really in full swing, and so there's a lot here to look at. Let's get right into this. One charge was dismissed before being handed over to the jury. We talked about this a little bit earlier. Can you talk about the gun possession charge and exactly why the judge ruled to drop that? He said this is going to be dropped. It's not going to be seen there. He heard a couple things, and then that's where we are right now. Break that down for us, please.
Early in the case, the defense lawyers brought a motion to dismiss the weapons count, finding that there was an exception in the statute which prohibits persons under the age of 18 from possessing firearms in the state of Wisconsin. The judge took that under advisement. The state didn't introduce in the trial the length of the barrel, which was the exception under the statute. Frankly, it's no great shakes to me. It's a Class A misdemeanor. The possession of the firearm by a juvenile is a Class A misdemeanor. If that's all the state achieved by way of guilty verdict in this case, it would be crushing.
But the jury does have the option now to downgrade certain charges. How does that play out?
The jury has been instructed by the judge, and they're very, very layered and complicated. But they're instructed to first consider the most serious charge, that is the first-degree intentional homicide, and to give their best efforts to come up with a unanimous verdict on the most serious of the charges. And if they're unable to do that with unanimity, to then move on to the next instruction, in this case, the second-degree intentional homicide.
Mr. Hart, Rittenhouse taking the stand, of course, in his own defense. We saw his emotional testimony, sobbing on the stand. Do you think this will play out well in his case? As others are saying, Rittenhouse created the carnage. Where do you think the two will meet?
Well, that was a critical instruction when the judge agreed to give the provocation instruction. In terms of his testimony, as long as they were going to put self-defense at issue, the only way that they could get that instruction was to have Rittenhouse testify himself. So it's emotional. It could go either way. There are those who believe that he was genuine. Others are less accepting of his genuine crying. Listen, I don't fault his team for putting him on. I think the self-defense was integral to the case, and without his testimony, you wouldn't have been able to get the self-defense instruction.
About 30 seconds left. This could almost be a yes or no. 18 jurors have heard this case. 12 will be randomly selected to determine his fate. That very well could be an all-white jury at this point, as there was only one person of color on that jury. How do you think this could affect the outcome?
Listen, race is a complex issue either way, right? None of the persons who were shot at or killed were people of color. The defendant is not a person of color. Certainly, you would like to have a cross-section of the community to decide cases, and we don't have that in this case, and that's unfortunate. The pool was limited in terms of the number of people of color that were available to be selected. In a perfect world, you'd like a cross-section jury of one's peers. We don't have that here. I'm not sure it makes that big a difference. In this case, the script seemed to be flipped, right? You have more the defense lawyers looking for the old, traditionally whiter population, and the state asking for a more diverse group. So, it's always tough, and race is a complex issue, as you know.
Yeah, it certainly is. Defense attorney Michael Hart, thank you so much for your time, and we'll probably be talking to you again through this process. Thanks.